Well, good afternoon, everyone. Welcome to the fabulous Hughes Trigg Ballroom. My name is Tom Mayo. I'm the director of the McGuire Center for Ethics and Public Responsibility. And on behalf of SMU and the McGuire Center, I'd like to welcome everyone here this afternoon for our public scholar lecture. The McGuire Center's primary purpose is to expose SMU students to ethics during their educational career at SMU, to foster an appreciation for ethics, to promote ethical acuity, ethical imagination in their lives and beyond SMU's walls. We do this through faculty grants for course development, research, publication, through our support of student activities designed to bring ethics into the classroom, through our awards as summer stipends for student public service internships around Dallas, around the country, and around the world, through conferences and programs designed to engage the entire SMU community and communities beyond our walls in discussions of major topics of ethical significance. Our Public Scholar Series, one each semester, does just that by bringing our most exciting scholars to the SMU and Dallas communities to engage them and our audience in a dynamic and exciting discussion. Carrie McGuire is a former trustee of SMU and is our principal benefactor. His initial gift to the center makes our existence and our activities possible, and I'd like to recognize Carrie's contributions to our activities now. Today's presentation is our 23rd Public Scholar Lecture, and it couldn't be a more timely example of ethics in action. I'm not the only one who thinks this. So does the State Bar of Texas. So all of the Texas lawyers in the room are invited to stop by the table along the wall to my right on your way out, where Terry Gwynn and Joanne Gonzalez have set up the bar sign-in materials for 1 hour of participatory credit, 1 hour of ethics credit. To introduce our speaker today, please join me in welcoming Professor Jenia Turner's and my valued colleague and friend in the Dedman School of Law, Professor Fred Moss.
Thank you very much. It's a distinct pleasure to be able to introduce my colleague on our speaker today, Jenia and Chiva. Close enough? Turner. Jenia and Chiva Turner. She is an associate professor here at the Dedman School of Law, where she teaches international law, comparative criminal procedure, and international organizations. When asked to introduce her, Tom asked me to introduce her. I said, "Do I have 30 minutes?" And he said, "No, how about 5?" And so I will try to cram into 5 minutes at most a overview of her young and yet remarkable career up to this point. Before she arrived at SMU in 2004, she had come a long way, both geographically, professionally, and I think personally. And I think through it all, and perhaps because of it all, she has shown throughout a distinct interest in international human rights and international criminal law and procedures and processes. She was born in Bulgaria, growing up in Sofia. Her mother, a biologist, her father, a psychiatrist. She went to a German language high school for 3 years in Sofia. And she was in Bulgaria when the communist regime fell, and as a teenager participated in pro-democracy demonstrations. She came to America when she was 17 to finish high school and to continue her education. She went to Goucher College. She was Phi Beta Kappa, graduated with honors, a BA in international relations. She was co-president of the college's branch of Amnesty International. While at Goucher, she spent a year at Cambridge, England, as a Kaplan scholar. When she then attended, upon graduation from Goucher, she went to the Yale Law School. She obtained a Shell Fellowship in International Human Rights. She worked for the ACLU Immigration Rights Project, and all the while being articles editor for both the Yale Journal of International Law and the prestigious Yale Law Journal. After her first year, between her first and second year at law school, she was a summer clerk at the Appeals Chamber for the International Criminal Tribunal for the former Yugoslavia. The next summer, between her second and third year, she worked in the Federal Public Defender's Office in Houston and the New York and Paris offices of Dubois Plimpton law firm. Upon receiving her JD from Yale, she went to the University of Chicago School of Law as a Bigelow Fellow and lecturer in law, where she was for 2 years at that time, teaching various courses, including comparative criminal procedure. And from there, fortunately for us, she came here. Her scholarship, as you can guess, is mainly in the areas of international criminal law, procedure, and human rights. And she has published articles in some of the country's most prestigious international law journals. I'll just give you a brief sampling of her productivity and the quality of the work that she has done. For example, after getting here in 2004 and 2005, she published in Stanford Journal of International Law the article Nationalizing International Criminal Law. The next year, 2006, in the American Journal of Comparative Law, she wrote the article Judicial Participation in Plea Negotiations. The next year, 2007, she published in the Michigan Law Journal her article Transnational Networks and International Criminal Justice. In 2008, she published in the Virginia Journal of International Law Defense Perspectives on Law and Politics in International Criminal Law. Last month, the Aspen publishers published her 320-page law school course book titled Plea Bargaining Across Borders. Her talk today, in a different form, will be published next month in the Chicago Journal of International Law. I don't have time to list her many, many speeches that she's given, but I'll just mention one. In January of this year, she spoke on negotiated justice at international criminal tribunals at the Hague Institute for Internationalization of the Law in the Netherlands. So as you can see, Professor Turner is intensely dedicated to international justice and the institutions and processes designed to achieve it. She spends a lot of her time overseas, researching, observing, interviewing participants in international criminal tribunals. At the same time, if that's not enough, she teaches a full load here at SMU Law School and is married with a 3-year-old son. And as you may notice, when she comes up, she's expecting another in January. So, just as on a personal note, she's also a genuine treasure as a colleague at the law school. You can see from her production, she is an asset to the law school and SMU generally, and so it is with great personal and professional pride and pleasure I introduce Professor Jenia Turner. Thank you.
Thank you all for coming today, and I would like to thank Fred for this very generous introduction, and to thank Tom Mayo and the McGuire Center for Ethics and Public Responsibility for inviting me to deliver this lecture today. It's a great honor for me to be among the many other faculty members and guests who have been part of this lecture series since 1996. The subject of my presentation today is legal ethics of defense lawyers at international criminal courts. My talk will be divided into 3 parts. I will first talk about the prevailing understanding of defense attorney ethics in the United States. Next, I will talk about the unique features and purposes of international criminal courts. Finally, I will talk about how I believe these unique features and purposes ought to influence legal ethics at international criminal courts. First, the ethics of the criminal defense attorney in the United States. Consider a hypothetical that has been used before in discussions of ethics in the US. The defendant has admitted to his lawyer that he mugged an elderly woman, and before she got a good look at him, he knocked off her glasses. The woman is now testifying that the defendant is the one who mugged her. Should the lawyer try to impeach her on the ground of her poor vision, even though he knows that the witness is telling the truth. In the United States, most defense attorneys would say yes. As zealous advocates, they would be duty-bound to impeach the witness if they believed this would be an effective tactic for the client. Robert Bennett, a well-known criminal defense attorney at the firm of Hogan and Hartson in Washington, D.C., perhaps most famous for representing Bill Clinton in the Paula Jones case, gave the following response to this very hypothetical. As zealous advocate, am I not permitted to rip the elderly victim to shreds on cross-examination and try to distort what I know to be the truth by suggesting that she didn't get a good look at the mugger, or that her sight was bad, or her recollection faulty because of age? Most would agree that such advocacy is considered ethically appropriate. Now, Bennett is not alone in this position, far from it. This appears to be the dominant view of criminal defense advocacy in the United States and other adversarial systems such as England, Canada, and Australia. For example, the standards for criminal justice established by the American Bar Association provide that, and I quote, defense counsel's belief or knowledge that the witness is telling the truth does not preclude cross-examination. American courts have also held that, quote, vigorous advocacy by defense counsel may properly entail impeaching or confusing a witness, even if counsel thinks the witness is truthful. Why is it that criminal defense attorneys are given so much leeway in this respect? Doesn't this interfere with the court's pursuit of the truth? Doesn't it interfere with a basic moral understanding that if one knows that another is telling the truth, one should not try to make that other person look like a liar? Bennett and other proponents of aggressive advocacy usually have a two-part answer. First, they say, such aggressive advocacy is justified in the unique world of our adversarial system. And second, it is justified because of the even more unique nature of criminal defense. The basic theory of the adversarial system is that the defense's primary role is to test the prosecution's case, to make sure that they prove it beyond a reasonable doubt. It is not the defense's role to seek the truth. That is the role of the court or the jury. In fact, a defense attorney would be usurping the jury's fact-finding role if he refrains from challenging testimony that the jury might reasonably doubt, simply because he knows or believes it to be truthful. In the adversarial system, we also give the defense important procedural rights to ensure that no innocent person is convicted. Indeed, we believe that it is better to acquit 10 guilty people than to convict one innocent person. We sometimes allow the truth to be undermined in a particular case to achieve this goal, and more broadly, to preserve important individual rights across the system. In addition, the special nature of criminal defense calls for particularly aggressive advocacy. Criminal cases typically pit the government against individuals with far less power and far less resources. And the stakes are very high. If the government abuses its powers, an innocent individual may lose his liberty and even his life. For that reason, criminal defense attorneys, more so than any other attorneys, should have more leeway in the tactics they can use in defense of their clients. Tactics that might be off limits in civil cases should be permitted in criminal defense. But how far can a criminal defense attorney go? Are there any limits beyond the formal limits established by the law to the tactics that he may use? Some criminal defense attorneys take the position that if a tactic is permitted by law and by the rules of ethics, the attorney must pursue it, as long as he believes that it will be effective. This view has been characterized by Professor Albert Altschuler of the University of Chicago as, if it is permitted, it is required. An eloquent and much cited description of this sort of zealous advocacy in criminal defense was given by the British barrister Lord Brougham in 1820. Here's how Lord Brougham put it. An advocate, in the discharge of his duty, knows but one person in all the world, and that person is his client. To save that client by all means and expedients, and at all hazards and costs to other persons, is his first and only duty. And in performing this duty, he must not regard the alarm, the torments, the destruction which he may bring upon others. Separating the duty of a patriot from that of an advocate, he must go on reckless of consequences, though it should be his unhappy fate to involve his country in confusion. Most American criminal defense attorneys would agree with Lord Brougham that an advocate owes no allegiance to any principles other than those imposed by the law and the rules of professional ethics. The advocate must subordinate all other considerations, be they moral, political, or social, to the duty to defend the interests of his client. Consider the following statement by Alan Dershowitz, a famous criminal defense attorney and Harvard law professor. The statement comes from Reasonable Doubts, the Criminal Justice System and the O.J. Simpson Case, a book that Dershowitz wrote about his work on the Simpson case. What a defense attorney may do, he must do, if it is necessary to defend his client. A zealous defense attorney has a professional obligation to take every legal and ethically permissible step that will serve his client's best interests, even if the attorney finds the step personally distasteful. Of course, this stricter view of defense advocacy tends to rest in tension with what we understand to be ordinary, everyday morality, especially when it involves the attorney in creating an impression that he knows or believes to be untrue. Defense attorneys themselves acknowledge this problem. For example, Robert Bennett, the attorney that I quoted earlier, candidly admits that the zealous defense attorney, and I quote, often speaks and acts in ways that to many are morally questionable, less than candid, and do not promote respect for the law in the eyes of the public. Partly in response to this potential conflict between ordinary morality and aggressive criminal defense advocacy, the American Model Rules of Professional Conduct do not take things quite as far as the view that what is permitted is required. The model rules do require that advocates zealously protect and pursue their clients' interests. But they also specifically provide that lawyers are not bound to press for every advantage that might be realized for a client. Several considerations might be understood to lie beneath the more moderate position expressed in the model rules. First, an attorney who understands it to be his duty to press for every advantage that is arguably legal will often find himself positioned on a razor's edge. He must balance his duty to represent his client zealously with his duties to the court, including prohibitions on delay tactics, frivolous motions, direct misrepresentations of fact, and subornations of perjury, and the like. A very strict duty to pursue all tactics available might be seen to make this balancing act even harder. Second, a lawyer must decide whether certain aggressive tactics will in fact advance the interests of the client, or whether they might alienate the court and the jury and harm the client's cause. Finally, every thoughtful defense attorney must wrestle with the difficult moral issues that accompany representation of clients who are, in most cases, guilty. Alan Dershowitz himself has acknowledged that, I quote, "If you're a decent human being and you've been a victim of crime yourself and you have family members that have been victims of crime, you feel tremendous turmoil." All of these difficulties weigh in favor of allowing defense attorneys greater flexibility than would be allowed under the philosophy of if it's permitted, then it's required. But should they entirely override the principle that a criminal defense attorney must pursue every tactic permitted by law that might benefit his client? These are very old debates. They have been thoughtfully addressed by many scholars and practitioners over the years, and I do not claim to have solved them. But what I want to discuss is how these considerations translate to a field that is somewhat new to us: international criminal defense. Before turning to the specific question of the ethical practices of international criminal defense lawyers, let me say a few words of background about the field I'm talking about. The international criminal courts at which these questions arise today are direct descendants of the Nuremberg Tribunal established in 1945 to try high-level Nazi defendants for aggression, war crimes, and crimes against humanity. We sometimes forget that the Nuremberg Tribunal was a novel idea for its time. It was not a foregone conclusion that there would be such a tribunal. Both in the United States and in Britain, many were against the idea of submitting high-level Nazi defendants, high-level Nazi officers and political leaders to a legal trial. Henry Morgenthau, Secretary of the Treasury and a close advisor to Roosevelt, argued that minor offenders could be sent back to the countries where their crimes had been committed to be tried. But the major criminals should simply be identified and shot. Simply, the British were originally opposed to the creation of the Nuremberg Tribunal. A Foreign Office memo argued that, I quote, "The guilt of such individuals is so black that they fall outside and go beyond the scope of any judicial process." Like Morgenthau, the British thought that it would be better to deal with high-level criminals in a more expedient fashion, by either letting public vengeance take its course or summarily executing them. But in the United States, there were also strong proponents of the judicial option, notably Henry Stimson, then Secretary of War. He argued forcefully that punishment after formal trials would have a very beneficial effect on future generations and would advance international law and international cooperation. In the end, that argument prevailed. The creators of the Nuremberg Tribunal, therefore, expected the court not simply to adjudicate guilt, a point that, in the minds of the Allies, was already conclusively determined, but also to achieve broader political goals. In his opening statement, Justice Robert Jackson, the chief prosecutor from the United States, noted that, quote, "The tribunal, while it is novel and experimental, was not created to vindicate legalistic theories. Instead," Jackson argued, "it was supposed to counter and condemn the sinister influences that the defendants represented. Racial hatreds, terrorism and violence, and arrogance and cruelty of power." The tribunal was to establish, in Jackson's words, undeniable proofs of incredible events, and to provide a historical record for generations to come of the evils committed by the Nazi defendants. Similar concerns motivated the Allies to establish the Tokyo Tribunal to try Japanese defendants for war crimes, crimes against humanity, and aggression committed during World War II. In short, already at Nuremberg and Tokyo, international criminal trials were seen as serving goals broader than that of determining individual culpability. These goals included promoting long-term peace and stability, fostering respect for the rule of law and human rights, and providing a measure of closure for victims of horrible atrocities. Because of Cold War divisions, it was not until 1993, almost 50 years after Tokyo and Nuremberg, that another international war crimes tribunal came into existence. This was the International Criminal Tribunal for the former Yugoslavia, the ICTY, which was created by the UN Security Council to deal with war crimes, crimes against humanity, and genocide arising from the conflict in the former Yugoslavia. More than 100,000 people were killed during that conflict. Millions were forced to flee their homes, and thousands were brutally assaulted, raped, and detained in inhumane conditions. In 1994, only a year after creating the ICTY, the Security Council also established the International Criminal Tribunal for Rwanda, the ICTR. The ICTR has jurisdiction over the same kinds of international crimes as the ICTY does: war crimes, crimes against humanity, and genocide, which occurred on Rwandan territory in 1994. In just over 3 months in 1994, more than 500,000 Rwandans were killed, and many more were brutally raped and assaulted. Soon after the ICTY and ICTR began their work, in 1998, state delegations from around the world came together in Rome to sign the Statute of the International Criminal Court, the ICC, the first permanent international criminal court. Like the ICTY and ICTR, the ICC has jurisdiction over war crimes, crimes against humanity, and genocide, and at a future date, over the crime of aggression. Unlike at these tribunals, however, the jurisdiction of the ICC is not limited to a particular territory. Instead, the ICC can hear a case arising from the territory of any of its member states or from the acts by any member state national. Its first cases have focused on international crimes committed in the Congo, Uganda, the Central African Republic, and Sudan. Like Nuremberg, the modern war crimes tribunals, the ICTY, ICTR, and ICC, have committed not only to determining individual guilt through fair procedures, but also to attaining broader objectives. First, they aim to establish the historical truth about the crimes. As the ICTY noted in one of its judgments, through public proceedings, the truth about the possible commission of war crimes was to be determined, thereby establishing an accurate, accessible historical record. In turn, this would help counter revisionist accounts of the conflict, restore peace, and prevent future acts of aggression. Second, international criminal courts aim to give victims a voice and a sense of closure. As the ICTY noted in one of its annual reports, witnesses who have come to The Hague have commented afterwards that the opportunity to testify before a duly constituted court has brought them great relief. Justice's cathartic effects may therefore promise hope for recovery and reconciliation. In addition, these courts see it as one of their goals to foster respect for the rule of law and human rights. Their decisions are supposed to express the outrage of the international community at the atrocities committed. The judgments are also intended to ensure that such crimes are less likely to occur in the future. These broad goals of international courts have shaped both the procedural and substantive law of modern international criminal court trials, to a much greater degree than they shape domestic criminal law and procedures. And as I will argue, it's reasonable to believe that these goals will also influence ethical guidelines at the international criminal level. Before returning to the question of ethical practices of attorneys, I would like to note one more way in which international criminal trials differ from American trials. They follow procedural rules that are a hybrid of our own adversarial tradition and of the inquisitorial tradition that originated in continental Europe in countries such as France, Germany, and Spain. As I will argue, these procedural arrangements also have a bearing on ethical rules at the international level. In inquisitorial systems, the trial is conducted as a neutral inquiry by the court rather than as a contest between two adversaries. As a result, the defense attorneys play a more limited role in the proceedings, whereas the judge plays a much more active role. For example, defense attorneys are generally not expected to gather evidence independently, and instead they must submit a request for further investigation to the court. Instead of collecting their own evidence, they rely primarily on an investigative file compiled by the state. And then they primarily work to interpret the evidence gathered by the state in a manner favorable to their client. Inquisitorial systems also place a greater emphasis on seeking the precise truth and creating an authoritative record of events. As a result, defense attorneys are also somewhat more limited in the tactics they can use to defend their clients. For example, they cannot suggest that their client is innocent if they know that to be false. And as a general rule, they cannot impeach a witness whom they know to be telling the truth. So, unlike Bennett and other attorneys in the American system, in other words, an inquisitorial attorney will not consider it ethically appropriate to vigorously cross-examine the elderly victim whom he knows to be testifying truthfully. Finally, inquisitorial systems do not urge or extol zealous advocacy the same way that we in adversarial systems often do. Their codes of conduct for attorneys nowhere mention zeal. Instead, they emphasize virtues such as dignity, probity, and humanity, delicacy, moderation, and courtesy, and competence, devotion, diligence, and prudence. At the modern international criminal courts, especially the ICC, this outlook has had an important influence. What does this mean for legal ethics at the ICC? Should the special features of the International Criminal Court, its inquisitorial procedures, or its more inquisitorial procedures, as well as its broader political goals, affect how defense attorneys conduct themselves when representing their clients? Before I attempt an answer, who are the attorneys who represent international criminal defendants? International criminal defense attorneys at the ICTY, ICTR, and ICC are about evenly divided between those who come from inquisitorial and those who come from adversarial systems, although lawyers from inquisitorial systems represent a slight majority at this time. The typical international criminal lawyer is not a lawyer with a political agenda, but rather an experienced criminal defense attorney interested in taking on a new professional challenge. The most common motivating factor for these attorneys seems to be the novelty and the professional challenge of international criminal practice. Most have extensive experience, more than 10 years, in practicing criminal law domestically. They typically begin work at international courts by submitting their name to the court to be placed on a list of attorneys eligible for assignment by the court. Over 90% of defendants in international courts are represented by assigned counsel because they cannot afford to hire one on their own. The defendants have some choice in selecting their counsel from the list of counsel eligible for assignment. They might select counsel on the basis of his nationality, his language abilities, or his general reputation. The international courts typically defer to the defendant's choice, but the court's administrators have the final word as to whether a particular defendant will be assigned a particular defense attorney. It's commonly assumed that international criminal defense attorneys are of the same nationality or ethnic group as the defendant, that only Serbian lawyers represent Serbian defendants and only Hutu lawyers represent Hutu defendants at the ICTR, for example. In fact, that's not the case. About half of the attorneys at the ICTY and virtually all at the ICTR come from countries other than those directly affected by the conflicts. The one thing that they arguably have in common is that they're willing to represent individuals who, at least in the eyes of the prosecutor, and frequently in the eyes of the entire world, have committed some of the most egregious and horrible crimes imaginable. Should these international defense attorneys approach their work in exactly the same way as some of them might do domestically, following the principle that if a tactic is permitted, it's required? I argue that they should not. Not every tactic that is permitted should be required of international defense attorneys. Instead, the unique features and purposes of international criminal trials suggest a more flexible approach to the ethical norms governing defense advocacy. I do not suggest that defense attorneys should ever fail to diligently or zealously represent their clients. I do, however, argue that in some of the areas that lie on the far reaches of aggressive representation, international defense attorneys should have greater flexibility than would be tolerated by the view that advocacy must always be pursued to the very limits of legality. Now, in the paper on which this presentation is based, I discuss 4 specific scenarios where I believe international trials call for a different approach to the ethics of defense advocacy. But in my remaining time, let me address just one of them. Should an attorney impeach the credibility of a witness that the attorney knows to be telling the truth? Remember the example of the elderly lady testifying against the attorney's client. The lawyer knows from the client that she's telling the truth, but he also knows that his client knocked off her glasses before he mugged her, a perfect opportunity to impeach her on the basis of her poor vision, should the lawyer try to do so. The Code of Conduct of the International Criminal Court does not address this question directly. It provides that counsel shall not deceive or knowingly mislead the court, excuse me, and shall not introduce evidence which he or she knows to be incorrect. A very broad reading of these provisions might construe them as prohibiting the practice under the theory that impeachment of truthful witnesses amounts to misleading the court. But this interpretation would seem like a stretch of the language that the drafters chose to use. There's a difference between affirmatively presenting evidence that an attorney knows to be false and the questioning of testimony that is presented by another, even if the lawyer knows the testimony to be truthful. So, the ICC Code of Conduct is inconclusive. How should the question be resolved? I argue that neither the distinctive goals of international criminal law nor the inquisitorial influence on the ICC's procedures support the impeachment of witnesses whom a lawyer believes to be truthful. Consider now a scenario more relevant to international criminal trials. A witness, a 20-year-old man, is testifying that he was forcibly abducted to fight for the defendant's rebel group when he was a child. The defendant's lawyer knows from talking with his client that the witness is in fact telling the truth. Should the attorney cross-examine the witness so as to suggest to the court that the witness in fact joined the rebel group voluntarily? If ethical rules were interpreted solely in light of the legalist adversarial model, the attorney would certainly be allowed, and very likely encouraged by the norms of his profession, to cross-examine the witness so as to make it appear that he joined the group voluntarily. Why should it not be this way at international criminal courts? First, the ICC does not follow a purely adversarial model. At the ICC, the proceedings are expected to be less partisan and more oriented toward a neutral inquiry by the court. If the defense attempts to discredit a truthful witness, this might be seen as inappropriate partisan behavior that interferes with the court's inquiry into the truth. Moreover, the ethical rules of the ICC do not require zealous advocacy. They require simply diligence, integrity, and conscientiousness. In other words, at least under the Code of Conduct of the ICC, defense attorneys are not duty-bound to press for every legally available advantage for their client. Second, impeaching truthful witnesses comes at a considerable cost with respect to other objectives of international trials. Objectives that I believe weigh more heavily on the scale in international trials than they do in domestic trials. Let's assume for a moment that in the scenario I just mentioned, the attorney actually manages to confuse the witness and undermine his testimony that he was abducted by the rebel group. This might prevent the court, as well as the public, and possibly history itself, from learning the full truth about the conflict and about the particular atrocities committed. Observers of the trial could be left with the inaccurate impression that children such as the witness joined rebel groups voluntarily. Now, it would be one thing if the lawyer believed this was true. But here we're taking it as a given that the lawyer knows it is not. Revisionist accounts about the conflict might gain ground and stir new tensions in the region. The educational function of the proceedings might be undermined. The attempt to discredit the testimony of victim witnesses would also interfere with the goal of providing victims with a sense of closure following great trauma or loss. In the scenario I mentioned, the witness could easily be further traumatized by the experience of testifying and having his honesty challenged. As studies of victims have shown, pointed challenges to victims' accounts of the crime can, quote, exacerbate their loneliness, alienation, confusion about what happened, and sense that they might be responsible for the horrors that befell them. Instead of achieving closure, in other words, victim witnesses might be forced to deal with additional anxiety resulting from attempts to undermine their credibility. All of these considerations weigh more heavily in international trials than they do at domestic trials. To be sure, vigorous defense representation is very important at international criminal trials as well to prevent the possibility of unjust convictions. But when it comes to tactics that are at the very far reaches of aggressive advocacy, there are times when the broader political goals of international criminal trials weigh against their use. Because of the scale and the gravity of international crimes, as well as the political element inherent in these crimes, the balance between the more legal and the more political goals is necessarily different at international than at domestic trials. I'm not sure how many international criminal defense attorneys would agree with my position. From conversations with international criminal defense attorneys, I know that many of them would decline to attempt impeachment of victim witnesses whom they know to be telling the truth. Even setting aside their personal view of the tactic, they say that they are concerned about how this tactic will look to the judges. The odds that it will backfire and that they will lose credibility in the eyes of the court are substantial. Despite these misgivings, those attorneys who interpret their ethical obligations as requiring the most aggressive tactics that are legally available may feel duty-bound to pursue such tactics. So, a clear indication from international courts that impeachment of truthful witnesses is neither required nor encouraged would help to address this concern. I therefore propose that the ICC include a commentary to its code of conduct that specifically addresses obligations with respect to the impeachment of truthful witnesses. It could include an explanation along the following lines. The lawyer's duty to his or her client does not require a lawyer to impeach the credibility of a witness on a particular point, particularly when the lawyers know that the witness is testifying truthfully on that point. The court urges lawyers not to attempt to impeach a testifying victim on a particular point when the lawyer knows that the victim witness is telling the truth on that point. The commentary would not impose an absolute prohibition on the impeachment of truthful witnesses, nor would it create sanctions for non-compliant behavior. It would take a more flexible approach in recognition of the differing practices of adversarial systems. At the same time, it would help promote an ethical standard that is more consistent with the structure and purposes of international courts. This approach respects the diversity of legal traditions that have helped shape international courts. It draws on the most appropriate practices from both the adversarial and inquisitorial systems to create ethical guidelines best suited to the objectives of the forum in which they're applied. The approach also recognizes and reflects the unique purposes of international criminal trials. The practices we permit and encourage in criminal trials say a great deal about the objectives we value in our system of criminal justice and how we balance them against one another when they come into conflict. the decision to create international criminal tribunals to deal with some of the world's most horrific crimes reflects an important commitment by the international community. To a greater degree than domestic proceedings, these trials do not merely aim to determine guilt, but also to compile an accurate historical record of the crimes, to spread a message about the importance of human rights, and to give victims of horrible atrocities a voice and a sense of closure. An understanding of these distinctive purposes is the best foundation for a system of ethics that is both effective and capable of widespread acceptance. Thank you.
We have time for questions this afternoon, and I don't know if we have an extra mic to walk around the room, but it's a pretty small room. Yeah, there is one here. Good point. I don't know. Yeah, okay. Here we go. Terry? Jenia's first contribution to our afternoon's proceedings was a brilliant talk. Her second contribution was battling a cold all week and making it through without losing her voice. So I hope we can continue both records during the question and answer.
Thanks.
Jenia, that was very interesting. Thank you. What does the lawyer do? What is the international criminal lawyer? How does she face the victim of the crime in cross-examination?
Currently, what do they do?
What would you recommend? How would the lawyer handle that?
I would urge them not to impeach the witness if they know that they're telling the truth.
So not to just sit down and let the witness go? That doesn't seem to be a very zealous role on behalf of...
She could cross-examine them on other points, but not on the points that she knows to be true, such as here, whether the person voluntarily joined the rebel group.
So that the victim could be cross-examined on things like treatment while part of the rebel group, that kind of thing.
Everything else.
Okay.
Jenia, thanks again for your talk. I'm wondering what your thoughts are on whether encouraging a lawyer to act differently based upon what he or she knows the truth of the case is, how that would potentially undercut justifications underlying the attorney-client privilege.
Justifications?
Underlying the attorney-client privilege?
Right. So this is an issue that's discussed a lot in domestic debates. Are you somehow revealing client-attorney privilege by by refusing, for example, to put a client that you know to be telling the truth, to testify and so forth. And I think that's an important consideration. I think it's more relevant when the lawyer is actually deciding whether to put client who's about to commit perjury on the stand rather than in this case, because in this case there's no obvious disclosure. So I think it's a relevant consideration, just like the general consideration of zealous advocacy. But in the end, I think it's outweighed in this particular circumstance by the duty of candor to the court and the other goals that I discussed that are relevant in international criminal trials, the broader goals, particularly the goal of advancing the historical record, and so forth.
Yeah. As I understood what you were saying, there were sort of three models that you're juxtaposing. There's the American, there's the European inquisitorial, and then there are these international criminal courts. And you seem to acknowledge that the European model all by itself sort of argues for a different kind of approach by defense lawyers. And so I guess my question is, it seemed as though a large part of the argument there was sort of who gathers the evidence, that argued for a sort of different approach. And I don't know if you sort of explained who gets the evidence in the international courts, but would that alone sort of argue for thinking about defense lawyering differently, or is that not a relevant difference between European and international procedures.
I think it's an important difference. The international criminal courts, however, are a mix of the inquisitorial and adversarial procedures. So defense attorneys are actually supposed to gather their own evidence, and they are given money to do that. And they hire their own experts, and they go back to the scene of the crime, and they investigate and so forth. But more so than in the US system, they have access to the prosecution's evidence. So that is critical. So that's one important difference. And again, in terms of questioning witnesses, I didn't mention this in my talk, but the court in international criminal courts is much more active in questioning witnesses, much more along the lines of the inquisitorial system. So again, it's supposed to be more of a neutral inquiry by the court, especially at the ICC, than this partisan contest between the two parties. So I think that has some role. Given that it's a mixed model, I don't know that in and of itself that's sufficient to justify a different ethics. I think it bears on the conversation, and it's an important factor, but I wouldn't say that in and of itself that's sufficient, particularly because, again, in international criminal courts, defense attorneys are supposed to investigate, and also something I discuss in my paper, I didn't have time for it during my talk, but defense attorneys actually face considerable difficulties in gathering evidence internationally. So much more so than in domestic trials. So that would weigh the other way, that perhaps they have to be more aggressive because of these difficulties that they face in gathering evidence on the ground.
First of all these international courts you mentioned are all based in Europe?
No, not all of them. So, the ICC and the ICTY are both based in The Hague. The ICTR was based in Arusha, Tanzania.
Okay. My question really relates to how do you handle the ethics of bringing someone in front of the court that might argue that within their framework of laws, what they were doing was perfectly justified? I mean, who decides?
Right, that's a big question for international criminal law generally. But the understanding is that because a state party consensually joins the International Criminal Court, so there are two parts to my answer. First is that the state party has joined the International Criminal Court, so the state of the defendant has acknowledged that it believes that war crimes, crimes against humanity, genocide, as they are described in the Rome Statute, are in fact punishable crimes, but also beyond that, these crimes at this point are considered to be, an international customary law. So even if the state party had not signed, there's an understanding that this is something that the international community has agreed upon. Now, there may be questions about particular elements of the crimes, whether those are international customary law, such as at what age is a child soldier, and so forth.
Because I can quote you with issues with China, with Sudan, with all around the globe as to how an international framework for judging their actions.
Sure, but even in the Sudan, I think the objections are not so much that we don't believe genocide should be punishable. They just say what we did was not genocide. So then it's a factual issue.
So it's hard to, I think your hypothetical make a lot of sense, and it's hard to argue with them. And this idea that at the outer limits, the council should have more flexibility, so what's permitted is not required. But there's still this thing that nags me, a difference between domestic and international, and that is, in the international prosecution, because of the sheer gravity of these offenses, there seems to be more of a presumption of guilt. So, the crimes are so atrocious that we almost presume that there is guilt, and that would seem to argue in favor of more zealous advocacy on the part of defense attorneys. So it's almost like up until a certain point you want more zealous advocacy, but then when you reach this outer limit, there should be more flexibility in order to achieve the goals of the international justice system, truth and victim victims' rights. And I just wonder, apart from the hypotheticals, is there a guiding principle for what the outer limits are of aggressive advocacy?
Well, I'm picking examples. I mean, I think there will be a lot of discussion about and debates about the middle ground, you know, what falls on the outer reaches versus what falls in the middle ground, but that's great. That's what the paper is trying to encourage. So I'm just laying out the outer reaches, and then the participants in the system can decide as to the rest, but what I'm arguing for is that they need to keep these goals in mind, that things are a little bit different in international criminal trials than they are domestically. So when they're engaging in these debates, you know, when defense attorneys are involved in the drafting of codes of conduct, and so are judges and prosecutors and the Assembly of States parties, you know, delegates, state delegates represented at the ICC. So when they engage in these conversations, what I'm arguing is simply that they need to keep in mind the differences and the special goals and features of international criminal law, whereas what seems to have been happening so far is inquisitorial countries want to have more their own model, and adversarial countries want to have more their own model, and they reach some sort of political compromise about what the rules end up being, instead of trying to look at the goals of the system and what that mandates. So I don't think there's a clear answer with respect to some of the trickier questions. What happens, you know, how do we determine, what happens if a lawyer simply believes but does not know that, you know, that the witness is telling the truth, or that the client is about to perjure himself, and so forth. So I think there are many difficult questions that come up on the margins, but there are certain questions that I say we can decide on, and the rest, you know, are open for discussion. So.
I'm going to pass the mic because I have a sore throat and I don't want to give it back. I have three really quick practical questions, all coming out of the cloud of ignorance of international law.
Sure.
So let me just, one of them is, what happens if the judge or judicial panel feels like the witness is truthful, but the defense attorney really doesn't?
Right.
Be aggressive, who calls that? The other one is, what if at the beginning we think the witness is telling the truth, but in the process of questioning the witness, we think, I don't know if this guy's telling the truth. Do you actually have to meet the judge and say, look, I want to go more aggressive, or how does that work? And then the third question is there an appeal from these courts? If you disagree with the ruling, is there another international appellate court?
Okay, last question first. There's an appellate chamber within the courts, so it's part of the court system. As for the first couple of questions, let me just clarify. Are you asking about what would happen under my model, or what happens currently? Or?
Well, I guess I don't know what happens now, so I'm just curious, administratively and kind of procedurally in the courtroom, how would that happen?
Right now, the attorney, as long as the attorney is not directly trying to mislead the court, the attorney is free to aggressively cross-examine, impeach whenever he or she wants. Under my model, again, I'm interested in the particular point that the attorney knows to be untruthful. Now, if the attorney suddenly decides, oh, there's some doubt, of course, yes, I would think that in that situation, the attorney should have the flexibility to pursue aggressive cross-examination, and I don't think the attorney will need any permission from the judge on that. But the judge may, I mean, what happens sometimes in practice is that judges are quite protective of witnesses at these courts. I should mention that, more so than in domestic courts. So they will, if they think that the attorney is getting quite aggressive with a victim witness, they will make that known. And the attorney will try to rephrase the question or what have you.
We have time for one more question. Ellie?
Yeah, thanks. My question is more historical in nature. You mentioned that, of course, the first war crimes trials were convened in the wake of the Second World War. What I'm interested in hearing from you is your view as to whether the ICTY, the ICTR, the ICC would have been established in the absence of those Second World War trials. How critical were they to forcing the world to look at itself differently and to reshaping its understanding of itself? Or are these processes things that were likely to have happened regardless?
Well, that's a tough question to answer. My feeling is that Nuremberg particularly, but both Nuremberg and Tokyo were critical to what happened. I mean, World War II started a whole new awareness about the importance of human rights. So it wasn't just the tribunals, but you have the creation of the UN, the Universal Declaration of Human Rights, everything that happened post-World War II. And it wasn't just the tribunals, but just generally the experience with World War II. So I would say that they were critical, and when the tribunals were being developed, they were modeled in many ways after Nuremberg. I mean, they were modern, there were various differences, but Nuremberg was seen as a model in many ways. So, of course I can't guess what would have happened had that not occurred, but I think it was critical, yes.
Jenia, thank you. I should have added earlier, and I'm happy to add right now, that in addition to having co-sponsorship from the Dallas Bar Association for this event, this is also being held under the auspices of the Human Rights Program here at SMU, which all semester long is conducting a series of events in observance of the Holocaust and the legacy that we have from our knowledge of Holocaust events. This is one of many events, and I encourage you to go to the Human Rights Program webpage to find out more about events that will continue, I believe, not only through the end of this semester, but carrying over into next semester for a while as well. The next one is tonight. We had the, you can say, the luxury or the just happenstance of scheduling that we have two events today. This evening, I believe at Meadows School, we have Prothrow Hall at Perkins. Ellie, this is God on Trial, I believe, isn't it? And it should be an incredible experience for those of you who can make it. I don't have the details for time exactly, but the webpage does have that, and by all means check it out. It's a phenomenal performance. So with that, I thank you all for being here this afternoon. I thank especially Jenia for sharing with us, and wish you all well for the rest of the day. Thank you.